Judgment in the matter of the Crown on the application of Marouf against the Secretary of State for the Home Department.
Lady Rose will explain the decision of the court.
The Public Sector Equality Duty, the PSED, is a duty imposed on public bodies by Section 149 of the Equality Act 2010. It is a duty directed at the decision-making process of public bodies. It requires them to have due regard when taking decisions to the need to eliminate discrimination, to advance equality of opportunity, and to foster good relations between different people when carrying out their functions. This appeal concerns the territorial scope of the PSED. Specifically, does it apply with extraterritorial effect so as to require decision-makers to consider the position of those who are outside the UK who might be affected by their decisions? The appellant is a Palestinian refugee from Syria who fled the Syrian conflict to Lebanon. The appellant asserts that she should be treated as eligible to come to the United Kingdom under the Vulnerable Persons Resettlement Scheme instituted by the government in 2014. I will refer to this as the scheme. The scheme assisted third country national refugees outside the UK, even if they had no connection to this country. In order to take advantage of the scheme, all candidates for resettlement must be people referred to the UK for resettlement by the United Nations High Commissioner for Refugees, the UNHCR. However, the appellant is not within the remit of the UNHCR because she is a Palestinian refugee. Palestinian refugees in the Middle East fall within the exclusive remit of a different United Nations organization, the UN Relief and Works Agency, UNRWA. Whereas one of the tasks of the UNHCR is to help refugees to resettle in another country, UNRWA has no such mandate. Thus, in practice, the appellant cannot take part in the scheme. The appellant brought judicial review proceedings challenging the lawfulness of the Secretary of State's adoption and operation of the scheme. The ground of challenge directly relevant to this appeal was that the Secretary of State had failed to comply with the PSED because she had not had due regard to the equality needs set out in Section 149 of the Equality Act. The High Court held that the PSED did have extraterritorial effect and did therefore require the Secretary of State to think about the way in which the scheme would not increase equality of opportunity for Palestinian refugees. However, the Court of Appeal arrived at a different conclusion and held that the PSED did not have extraterritorial effect. The Court of Appeal held that a duty to have due regard to the need to enhance equality for anyone, anywhere in the world, regardless of a local authority or a public authority's actual power to advance that, would be a meaningless duty. There was nothing in the wording of the Equality Act, the Court of Appeal said, to suggest that Parliament's intention was that English public authorities would have to think about these things when making their decisions. The appellant now appeals to the Supreme Court. The Supreme Court unanimously dismisses the appeal. The starting point for considering the scope of the PSED is the presumption in domestic law that legislation is generally not intended to have effect outside whichever parts of the United Kingdom it expressly says it applies to. Sometimes an act will contain a provision that makes clear that it is supposed to apply elsewhere. Even if an act does not expressly say this, there are some cases where it is so plain that it must have been intended to apply elsewhere that the courts will say that it is implied in the legislation that it does so apply. But in the absence of an express statement or necessary implication, an Act of Parliament will not apply to people and matters outside the territory to which it extends. And in the absence of express words, although an extraterritorial application of legislation may be implied, it is a high threshold that needs to be overcome before the court will conclude that it does. this is a well-established principle that has been applied for very many years to very many enactments. In our case, there are no express words in the Equality Act saying that the PSED applies outside England and Wales and Scotland. The appellant's case therefore rests on whether such an intention can be implied. Her primary case was that the whole of Section 149 containing the PSED has extraterritorial effect. She argued in particular that the Secretary of State had failed to have due regard to the need to advance equality of persons who share a relevant protected characteristic, in this case being a Palestinian refugee, as compared with persons who don't share that characteristic, in this case other refugees. The Supreme Court holds that there is nothing in the legislation from which one can imply that the presumption against extraterritorial effect has been overridden. On the contrary, the scope of the equality goals set out in Section 149 as goals which public authorities should aspire to achieve suggests there is no such intention. The PSED is intended to ensure that the specified public bodies have due regard to the need to adopt policies that will help to bring about the kind of societal change that would see the elimination of discrimination and the promotion of equality of opportunity and good relations between different groups within the community. There is no duty on public bodies under the PSED to attempt to bring about that kind of change in countries outside the United Kingdom. Furthermore, if the whole of the PSED did have extraterritorial effect, in most cases there would be no point in the public body thinking about this duty, either because their decisions have in fact no effect on people outside the UK, or if they do, there is nothing that the public body can do to change society in those other countries. If there is likely to be no useful purpose served in most cases by imposing the duty with extraterritorial effect, that makes it less rather than more likely that Parliament intended to extend the scope of the duty beyond this jurisdiction. Sometimes, of course, where decisions and policies are being discussed within a government department, it will make sense for them to think about whether the effect on people overseas is likely to be advantageous or disadvantageous from the point of view of the United Kingdom's overall interests. But the wisdom of having such an internal discussion as part of policy making certainly does not mean that the PSED should apply extraterritorially. In some cases, the nature of the decision being taken may of itself mean that the minister ought to take into account the need to minimise disadvantages suffered by persons who share a relevant protected characteristic in a foreign country where the decision will be implemented. But where that really is a relevant factor, then if the minister fails to consider it, that decision will be open to challenge for failure to take that into account in accordance with the ordinary judicial review principles. You do not need to rely on the PSED to achieve that. The appellant's alternative case was that under the PSED, the specific procedural duty to have due regard to avoid the unlawful discrimination has extraterritorial effect. The appellant relies on the Court of Appeal's decision that the substantive prohibition on unlawful discrimination did have extraterritorial effect to a limited extent when a particular refugee is refused access to the scheme. Although the Court of Appeal held that there had actually been no unlawful discrimination in this case, the appellant argues that the territorial scope of the procedural duty under Section 149 must be as wide as a relevant substantive provision elsewhere in the Act that sets out the duty not to discriminate. The Supreme Court disagrees. The PSED is primarily directed at policy decisions, not at the application of policy to individual cases. The appellant's argument would confer rights on people all over the world to challenge the decision-making process of a public body exercising its functions if the exercise of those functions affected them. Given the very serious implications of that construction of the legislation for public bodies, the Court concludes that if Parliament had wanted to achieve that, it would have made this express in the legislation. For these reasons, the Supreme Court therefore dismisses the appeal.
The Court will now adjourn.